Any mention? Any mention?
Yes.
From supplementary list, item number 1.
May it please, Your Lordship. Lordship, through this writ petition, Lordship, we are praying for extension of time for completion of proceedings against the respondent, Lordship. Lordship, through this writ petition, we are praying for extension of time, Lordship, for completion of proceedings against the respondent.
Oh, not yet been served.
Lordship, the
Service has not been complete. What is it you are saying?
no, Lordship, it has not yet been complete.
You want time to work. Oh, the matter has been remanded
Yes, Lordship.
for continuation of the proceedings. You have not completed the proceedings.
Lordship, it has been completed. Ma'am is appearing on behalf of the respondent.
May I please, Your Lordship? My Lordship, similar matter in item number 12, WPC 1 of 2024 is listed today in courtroom number 2. So, my Lordship, my humble prayer to let it be tagged up together as both the matters are interconnected.
Very same respondent is a petitioner there.
Yes, my
What is the relief sought for in the other petition?
My Lordship, in that matter, the matter is revolving around that the respondent has openly flouted the directions of the judgment and order of the Honorable Division Bench of the High Court of Meghalaya in WPC number 444 of 2020, whereby the proceedings should have been completed, my Lordship, by 31st/8/2022. But the respondent failed to do so, my Lordship.
You reinstated.
Yes, my Lordship.
Reinstated pursuant to the orders of the division bench.
Yes, my Lordship.
Sorry, ma'am. My lord, we come before
You have to allow the junior to argue.
my lord.
You address.
Lordship, through this writ petition, Lordship, we are praying for extension of time for completion of proceedings against the respondent.
That is right. She says that you have already filed a writ petition there,
Yes.
seeking for further extension. See, that apart, if you see the records, you have been absented for more than 4 years, or nearly 4 years, on different periods. You are only a typist, is it not?
Yes, Lordship.
Typist. This is against the order of the
Lordship, we are for
Central
the
Administrative Tribunal. No.
Lordship, we are for the Department Union of India. We are representing the Department Lordship Union of Assam Rifles.
Representing the respondent.
Yes,
One
Lordship,
day
in the
petitioner is standing here, one day respondent is here, so I got confused. Yes, madam. So you are absented for nearly 4 years. See, you do here. Please ensure that one person stand this side. Petitioner be here, respondent be here. So till yesterday, I was under the impression that the petitioners are here and respondents are here. Yes, no problem. Now leave it. Now leave it.
My apologies for that,
Yes.
my Lordship. My Lordship, we could have filed the contempt, but because the entire proceeding is vitiated and nullified, there has been an inordinate delay, which has been conducted by them, my Lordship. That's why we have filed writ petition number 1 of 2024, requesting this Honorable Court to look into the matter as to give them the opportunity to clarify as to why this inordinate delay crossing the orders of this Honorable High Court has been done, my Lordship.
See, the appeal papers, in para number 5, it has been stated that you have admitted the charges.
may it please, Your Lordship.
Para number 5.
My Lordship, I am the local counsel here, so I do not have the entire brief of the matter, my Lordship. My senior counsel, Mr. Harish Bitala, he...
Ensure that, don't say that senior counsel. The instructing counsel must also be ready to argue the matter.
My
See,
Lordship,
that way,
kindly...
we ask the senior to sit down. the junior to address.
My lordship, kindly a short date may be
See,
fixed.
now if you take para number 5, there is an admission by you about guilty of the charges. And you have been absented for 4 years. These are Assam rifles. How are you entitled to continued service? How can they run the institution, organization?
My lordship, responding, my lordship, he had taken the extra leave. It wasn't willful, my lordship, because he had
You
to.
said your daughter was not well and wife passed away. These are the reasons given, is it not?
No, my lordship, kindly allow me. My lordship, he was admitted to Agra Hospital due to a severe back pain, whereby he had also produced all his medical records, which were also verified by the inquiring officer there, my lordship.
Do you have the paper book, the form? Part 2? Do you have the papers filed by them? You don't have a single paper.
No, my lordship.
Daughter is unwell and suffering from serious mental illness. That is your plea. You say it's not correct.
No, my lordship, that is the matter for
You
which he
say that
had.
wife expired in July 2012. I've read the papers. See, you can't be absenting yourself for 4 years and say plead that it should be. Strictly speaking, the procedure was initiated. The earlier division bench should have followed the order of the Supreme Court in Ramzan Khan case and ECL Karnataka case, where they said that you conduct the inquiry, don't pay wages. The wages will be depending upon the outcome of the proceedings. Suppose they have not allowed you to earn wages, then you would have participated in the inquiry.
My lordship, if you allow me, earlier when he had taken the leave, he had
We'll
taken.
call the matter on next Wednesday, you argue the matter.
Much,
Wednesday, your senior should come.
much,
Now that you have come, you must continue.
much.
Madam, one other thing is that she was only a typist.
Yes, Lordship.
Only a typist. And she has rendered 16 years of service without any blemish. And of course, 4 years absence. Whether the capital punishment of removal from service should be imposed. Because originally the punishment imposed was stoppage of increment, which was reviewed by the disciplinary authority, and the punishment of removal from service was imposed. You decide whether any other punishment can be imposed on the writ petitioner. That also you ascertain in the next hearing. You decide the case based on the records. But in order to give a quietus to the matter, we are thinking, after all, we are typists. It's not a very important thing, like where in Assam Rifles, the other persons are working. You also, sir, you also get the instructions. Whether any other punishment can be imposed.
My lord, it's actually what happened, my lord, the division bench of this honorable court remanded back the matter for de novo inquiry, my lord. And a time frame was fixed to complete the inquiry within certain period. We could not complete within that period, my lord. So, my lord, that is still open. If we are allowed to continue with the inquiry, my lord, we may impose a lesser punishment, my lord.
Now itself, if you come with a suggestion, why should there be another proceeding? We can give a quietus here itself.
My lord, I'll come back.
You inform us what is the punishment that can be given.
My lord.
We will say that the punishment, let them accept the punishment.
My lord. On Wednesday, I'll come back.
If you are not going to accept the lesser punishment, then we will confirm the order of removal from service.
Much obliged, ma'am.
Wednesday.
My dear Lordship.
Because there is a judgment of the Supreme Court, that when it shocks the conscience of the court,
Well,
the court is empowered to interfere with the punishment.
proportionality of punishment.
Yes. Proportionality of punishment.
Well,
From the daily list,
We expect the council here to address argument. One adjournment at the maximum can be sought for on genuine reason. One reason, one adjournment for petitioner, one adjournment for respondent is not correct. Only one adjournment for the case.
much
deeply.
from the daily list, item number 1.
Please, Lordships. This is an appeal directed against the judgment in order dated 29/2023. The issue here is, my lords, with regard to a tender process.
A tender process.
My lords. There was a tender, my lords, for lightning arrestor systems.
Yes, sir.
Lords, I was one of the participants of the tender process, my lords. Now, my bid was rejected at the technical stage on 2 counts, my lords. That fines mentioned in the orders of the learned single judge. That I was the authorized agent, my lords, of a certain company called JMV. LPS Limited, my lords.
In para number 8, 2 reasons are given by the learned single
My
judge.
lords, I was just coming to that. I'll have to address your lordships only on those 2 issues. My lords, what had happened is at the technical stage, what the respondent says, they sought a confirmation email from that JMV, the company which had authorized me, my lords. And they apparently received a letter which says, my lords, that my authorization vis-a-vis this particular contract has been cancelled by that parent company. Your lordships would find that cancellation, my lords. I'll just take your lordships directly to that cancellation order. Your lordships would find it at page 744, part 2 of the paper book, my lords.
700?
44, my lords. 744. No, I'm sorry, my lords. This is the authorization. The cancellation is here. Sorry? 802. 802. 802 and 803. 744 is the authorization. Your lordships may kindly have a look at 744 first, my lords.
Yes.
This is the authorization, my lords. This is dated the 8th of July 2023. And my lords, the cancellation, your lordships would find at page 802. 802 is the email, my lords, and 803 is the letter. My lords, at 802, if you may kindly see, my lords, down below is the original email. It reads, it is requested to please confirm that your firm JMV LPS Limited has offered authorization to Pragati Engineers for supply and installation of ESE-based lightning conductors against GM bid number so-and-so, dated so-and-so, uploaded by the Assam Rifles for installation of the product at location Assam Rifles in Northeast, and early responses requested as the bid is under technical evaluation process. This is routine confirmation required by the buyer's side to check the authenticity of the sellers participated in the said bid. Now, the reply to that email is, my lords, what is within that box. They say, this is to inform you that our firm, Messrs. So-and-so, has cancelled the authorization of Pragati Engineers immediately after issuing, as our working terms were not matching with them. Also, Pragati Engineers was clearly informed not to place the authorization of so-and-so, so-and-so, uploaded by so-and-so in the product of so-and-so. With this, we hereby confirm that we do not authorize so-and-so. This is what they say, my lords, is the email received by them. The letter, my lords, is at page 803. If your lordship can have a look, my lords.
Yes.
Now, your lordship would first kindly see, my lords, this particular letter is simply signed by an authorized signatory. Well, it says that this is with reference to OEM authorization, which was emailed to you on so-and-so. With this letter, we'd like to cancel our authorization as we understand that our working terms may not match with the organization. You are hereby advised to treat our authorization as cancelled. Now, there is no name signature of anybody who has issued this letter. And why I was drawing your lordship's kind attention to page 744.
For 803, there's a signature is there.
It's just a signature, my lords. It does not say who's issued this letter. If your lordships kindly see 744, the original authorization. How an authorization is issued by the company. Now it says, my lords, designation, director, technical, email ID, so and so. Now, the requirement for this, my lords, why this is required, your lordships, in the terms of the contract, it specifically provides that when any letter of authorization is produced before the authorities for the purposes of a tender, the email address, the designation, and the contact numbers of the person issuing that letter should mandatorily be available in that letter. Now, what we are saying is, my lords, we were caught by surprise by this certain letter which was produced by them in the proceedings before this honorable court, because insofar as we are concerned, my lords, there was no communication to us insofar as this letter.
So you have not received this communication?
We say, my lords, that was never communicated to us. Because it comes as a surprise, my lords. Your lordship will kindly appreciate, on 8th of July, a letter is issued, my lords, authorizing me to participate in a tender bid. And on 1st of August, they issue a letter saying that we've cancelled the authorization.
8th of July is the email.
My
Sorry, 8th of July is the letter.
My lords, 8th of July is the letter, 1st of August is the cancellation. That's one aspect of the matter, my lords.
Yes.
The other thing as well as the email that I produced before lordships is dated the 11th of August 2023.
Email at the 802
Yes, my lords.
is date.
On the right hand side, your lordships will kindly see on that box, my lords, the right hand side top upper corner, August 11, 2023 at 8:01 p.m. Now, the language of this email is again very interesting, my lords, may kindly see. This is to inform you that our firm so-and-so has cancelled the authorization of Pragati Engineers immediately after issuing. Now, the cancellation order, my lords, which has been produced, is dated the 1st of August.
Yes.
So, my lords, our contention before, my lords, the learned single judge was that this letter was never produced or we were never communicated with this order. It was only when, my lords, that they had annexed it in the affidavit in opposition, that is when for the first time we got to know that there was any such letter of cancellation. In either event, my lords, one of the points that we had urged before the learned single judge is that the manual provides that in such circumstances, a clarification can be sought from the petitioner or any participating firm in the tender process. So we could clarify, my lords, what is the position with this? We could seek a clarification even from the authority, even from the company which had issued the original authorization letter. Because here what had happened is, my lords, before this matter came to this particular writ petition, there was already a challenge made by us with regard to the tender conditions. After we had moved this honorable court, my lords, a corrigenda was issued modifying the tender terms. Now, thereafter, my lords, when we participate in it, in the technical bid stage, my lords, suddenly we are met with this particular letter, whereby they say, my lords, that my authorization itself is gone, so therefore I am ineligible to participate in the tender process.
So what is the stage now?
It's that I think my learned friend would be in a better position to apply.
On 14th of September, the work has been awarded to the L1 bidder, my lord.
And been awarded.
And he has carried out substantial work. We are in the month of February now, my lord. So 5 months gone, my lord. And moreover, the successful bidder has not been arrayed as a party, my lord.
So I can implead him as a necessary, as a party for that. Why he's not a party is because, my lords, when this writ petition was filed at that point of time, the work had not been awarded.
Correct. Because of the no interim order, it has been awarded, the work has been carried out.
My lords, my lords.
Much water has flown.
Water has flowed, my lords, but the only issue here is, my lords, that we say, my lords, that the work has been awarded to a firm which has no experience in lightning conductors. And the petitioners before the lordship, my lords, has an experience of almost 40 years in this field of lightning conductors.
My lord, kindly see the dispute they are trying to project, my lord. That is a dispute between him and the JMB, my lord. My lord, we as a department, my lord, the tendering authority, we are not a party to that. What is his arrangement with his supplier, my lord? because he is not a manufacturer of any article, my lord. He entered into some agreement with some manufacturer, my lord, the JMB. Now JMB says that he is not unauthorized. Now in these circumstances, how can we qualify him for technically, my lord?
Which is why, my lords, the manual provides for seeking a clarification. If there is a situation like this, my lords, if a bidder, my lords, I go somewhere on the basis of an authorization given by a company, I apply, my lords. Rightly, my friend has pointed out
Any
that
loss is caused to you to seek for damages, but the relief cannot be granted in this case now. Much water as well. Come. The present appeal has been preferred. Present writ appeal has been preferred against the order of the Learned Single Judge dated 11/9/2023, WP 234 of 2023, rejecting the plea of the writ petitioner and not interfering with the tender. Full stop. During the course of the argument, it has been stated by the writ petitioner that he has got 40 years of experience and that the communication dated by
1st of
communication dated 744
well, it's 1st of August and 11th of August.
was July.
The cancellation is, my lords, dated the 11th of August, my lords.
1st August.
No, the email.
By means of communication dated 8 July 2023. The Pragati engineers or the writ petitioners have been authorized, which was valid till 2/7/2024. So, without any notice and intimation, the authorization was cancelled on 1/8/2023 and the email, which reads as follows, is dated 11th August 2023. According to her, the writ petitioner, since the writ petitioner is the successful bidder, the cancellation, more so which was not brought to their notice, and the same was brought to the notice after the writ petition was filed, cannot be looked into as the person who has signed the communication dated 1st August 2023 is not known, whereas in the communication dated 8/7/2023, the Director Technical has given the authorization. Whenever an authorization is given, the authorized signature is, apart from authorized signature, authorized person signature, the designation, email address, and the telephone number should be reflected. The same is absent in the communication dated 1/8/2023. So various plans have been advanced, the counsel for the respondent, inter alia, submitted that the tender has been awarded to third party by name so and so, and he has carried out 75% of the work.
40% of the work. Substantial work, 40%.
40% of the work, and that at this distance of time, disturbing and cancellation would affect the entire process for which the tender was issued. You would further contend that the person who has been awarded with the tender has also not been made as a party. Hence, on that score, the appeal has got to be rejected. Full stop. You would further submit. The learned single judge has given 2 reasons in paragraph number 8 of the order for rejecting the tender. Full stop. Heard both parties. So, the petitioner would submit, the writ petitioner would submit that he is a successful bidder and that there was a cancellation. Comma. In the present writ petition, in the writ appeal, we are not inclined to go in detail with regard to the various factual arguments made by the party concerned. Since the tender has been awarded to third party by name so and so, and that he has not been made as a party before the court, and that there is a dispute between the writ petitioner and the person who has not supplied the materials, comma, leaving open to the petitioner to claim compensation if so advised in case of any violation with regard to the grant of tender. We are not inclined to grant the relief as sought for by the petitioner as tender has been awarded, which is by which 40% of the work has been carried. Yes.
Right.
Item number 2.
Wait, please, Your Lordship. Your Lordship, the amicus curiae was hospitalized, Your Lordship.
You are the amicus curiae?
Yes, Your Lordship.
Yes, madam.
I kindly pray for 1 week time, Your Lordship.
One time.
Yes, Your Lordship, 1 week
From
time.
2017, the matter is pending. 15. Writ petition 164 of 2015. We are going to celebrate a decade. The reason for appointing amicus curiae is to assist the court. And several adjournments have been taken. The matter has gone to the Supreme Court. And there is a direction by the Supreme Court also. With regard to expansion of yesterday or day before yesterday, I saw it in the paper that the area is not sufficient, only ATR alone can land, and many people are not interested, and they want a bigger place for the bigger aircraft to.
Well,
I think yesterday paper or day before yesterday paper.
what has happened, my lord, is that there has been an obstruction by a certain hill, because of which the larger crafts cannot land there. So I think right now they are trying to come out with a solution to that problem. As of now, it is only the ATRs and the smaller crafts. But probably the acquisition and all was done with the idea of making it possible for larger crafts also to land.
So do you think that it will work?
But at a certain time, they had said that it would not be possible, but now I think they are giving it a retry. Retry. That's what it is. But in this particular acquisition, because the land was taken from the adjoining land of the army. So this acquisition with which we are dealing here, Milad, this is for the purpose of compensating the army. The army said that we do not want money, but you compensate us with land.
Land.
So that is the acquisition which was done, and out of which this instance.
Compensation will have to be paid to the person from whom the land has been taken.
My lord. Well, initially, my lord, what happened in the acquisition proceedings, certain compensation was given to a certain persons. Now, aggrieved by that, my friend's client, they approached the Honorable Supreme Court. And the Supreme Court framed 2 issues and directed that the inquiry should be done by the district judge. So pursuant to that, the matter came back to this Honorable High Court and it was sent for inquiry. Now, after the inquiry was completed by the predecessor of the present district judge, he submitted a report. But that was not found acceptable because the issues raised by the Honorable Supreme Court, those were not answered. So, by the order dated 21st of February 2023, last year, the matter has been referred back again to the district judge. So, district judge conducted a detailed inquiry in which all of us participated and has submitted a report. Now, our humble submission before your lordships now is that if we are the private parties, the claimants, if we be given copies of the report, and then, of course, the amicus curiae has already got a report copy. So, if you are also given, then we can see the
Make your submissions already.
on
Now you are concerned about the higher compensation.
higher compensation and also the who are entitled to the compensation. There are two issues were raised by the Supreme Court. One is that whether
This court decide who are all entitled to compensation. Only the district judge can say who are all entitled to the compensation.
that's what that is the inquiry which has been completed. The inquiry was on that only. Two issues were raised by the Supreme Court. One is that whether excessive compensation was granted in the
Give them the copy of the report. Let them also have a copy of the report. Yes. Give them a copy of the report. The report has been filed here.
Madam.
Report dated 20th. This is the report. 25/8/2017 is one report is there.
Problem that it is dated 18/10/2023.
18?
10 October 2020. That is the last inquiry report, the latest one.
Or 18th October. Yeah.
So now basically we are concerned with this latest report.
We'll go through the report and then we'll take up the matter. And there also, amicus curiae also wants time.
Madam.
When the matter is taken up for hearing, senior advocate appearing for the respondent would submit to the proposal with regard to having land for aerodrome was in dispute. Now that the proposal has come, now that there is a possibility of aerodrome in the place identified, the only issue is whether the landowners are entitled to the compensation, which is not minimal, full stop. A senior advocate would also submit that there was an earlier report filed by the district judge pursuant to the orders of the Supreme Court, and that the report was not satisfactory. Hence, the matter was asked to be re-looked again by the district judge, and the district judge has submitted a report on 18/10/2023. Would further state that he has to go through the report for them to submit on the acceptance of compensation. The counsel representing amicus curiae sought 2 weeks' time. The request of parties pose the matter. Complete. Today we are on 22nd, 29th, 7th or 8th of February, March.
Item number 3.
According to the land belongs to the said that they require only land, not compensation.
My lord, my lord. That is the thing. For that purpose, fresh acquisition was done. Obliged.
But what is the news item that appeared yesterday or day before yesterday with regard to the ATR and not a bigger one, bigger
That's
aircraft?
what, because, my lord, the effort was to extend the runway and make it possible for larger aircrafts to land. Now, I think, as far as I understand, that effort is still going on, and whether it's possible or not, on that, probably some reports had come up.
My lord, the PIL is pending
But in
regarding
that
that.
regard, one PIL is pending. I am saying for airports authority, my lord. But here what happened, my lord, this airport was conceptualized in 1960s, my lord. And the runway space is bit short, my lord, where larger aircraft cannot land. And on the both sides of the runway, there are hills, my lord. So, effort was, a survey was done, my lord, and we are again resurveying it if there is any possibility of extending the runway, my lord. Because it affects the flight trajectory of the aircraft. The hills are coming on the way, my lord.
If I understand correctly, one
See, though it has been stated that Meghalaya is a backward state, after seeing the technology here, definitely I will not say it's a backward state. Definitely not a backward state, because I will compare to the system, the technology which is available here, the Madras High Court lacks. It's far behind.
I think we are grateful to.
So, see, for the purpose here, this state need to be improved in one side because it's a tourism place.
Right.
Unless the airport or any other facilities are made available,
Right.
you can't bring the economy to a higher level.
Right.
So for that, everyone should cooperate. So there, the land belongs to the government, and the government will have to allot the land. Here, the land belongs to the person, so government will have to pay and buy the land,
It's all private land.
all private land.
Yes.
Obliged.
I have this.
Yes.
Fine.
Item number 3.
May it please your lordship. Your lordship, I kindly pray for 2 weeks time, lordship.
Madam,
I kindly pray for 2 weeks time, your lordship. The standing counsel for my corporate, your lordship, he is unwell. Respondent number 4, your lordship.
you for the appellant.
I'm for the appellant, my lord. I'm for the appellant.
You for the appellant.
Number 4.
What is the matter about?
Lordship, here I'm challenging the impugned judgment order passed by the learned single judge, my lord, 21st-9/2023, wherein the learned single judge has held that the appellants are not entitled to gratuity and leave encashment on the ground that they are not regular employees, my lord,
Yes.
but fail to appreciate, my lord, that the matter is covered by judgment and order dated 10/7/2013, my lord.
Then?
10/7/2013, wherein the learned single judge,
Then why did you approach this court after 10 years? 2001 you have received the compensation,
Lordship,
one-time compensation. 2022 you have approached this court.
Lordship, my contention before the court was like, my lord, that it is a judgment of time, my lord. And then similar situated persons also, my lord, was already,
We are not on that.
Lordship.
If you got your case, there is a delay in approaching the court.
Lordship, a similar situated person also was granted the same relief, my lord, who approached in the year 2021, my lord.
Where is the order?
Page 109, 199, my lord, 199.
No, 99. Under 19, with regard to succession certificate, sorry, petitioner does not approve the respondent one for valid succession certificate.
No, my lord.
You said 199. Yeah,
Page 199, my lord.
yes. 199 is a succession certificate, Annex 7.
201, my lord. Here, in this particular case, my lord, the legal as they approach the court, my lord.
You are not on the way. Who is before this court is different.
Page 201 also, my lord. When the matter was pending before the court, it got to gratuity and leave encashment, my lord. The respondent, my corporate, my lord, they granted.
How do you say that the deceased was entitled to gratuity? Now the legal answer before this court, is it not?
In that particular case, my lord.
In that case.
In that case, my lord.
In this case, the employee is before.
Yes, employees before this court, my lord.
Yes.
No, here also in another case,
How do you say that now you are claiming gratuity as per the Payment of Gratuity Act?
lordship,
Is it not?
lordship,
Referring to section 1.3 must be 1.3 or so.
lordship.
Correct? If that is the case, where is the proof that you have worked for 240 days in a year? Continuous service.
Because they are in affidavit opposition also, my lord, they are not denying that I've been an employee of Mecofet, my lord. They are not denying. They are not denying, my lord, in their affidavit opposition. They are
You
not
have not
denying.
denied your employment. What
Lordship.
about the number of days?
Number of days also, my lord, I was appointed in the year 1980, my lord.
Yeah,
Then I've been serving till 21 years, my lord. Then they had to release me on a voluntary retirement scheme, my lord, that golden handshake scheme. Then we took that golden handshake scheme on one-time basis, my lord. And after that, they release us.
What is the one-time scheme?
One-time payment, my lord.
What is one-time scheme that you have based on which a compensation is paid to you?
It's a golden handshake,
One-time scheme, is it not? One-time settlement.
lordship,
That were based on that you have been paid.
lordship.
According to you, the payment of gratuity paid to you is less.
No, it was not on payment of gratuity act, my lord. Not on that aspect, my lord.
Oh.
They came up with a scheme saying that since the respondent McAfee were incurring losses, they had to discharge our services, my lord, and give us one-time payment, my lord.
Sir, you are claiming the benefit based on the Payment of Gratuity Act or based on one-time settlement.
Now they are saying that I'm not even entitled to Payment of Gratuity Act, my lord.
You are not entitled to gratuity.
That is what the claim is, my lord.
That is their case. According to you, they are
My case is that since
entitled to gratuity. And
I'm entitled to gratuity because this learned single judge, my lord, in the year 2013, held that Payment of Gratuity Act is applicable to McAfee. Thereafter that, my lord, they challenged before a division bench. Then it traveled up to Supreme Court, my lord. Then in the Supreme Court also, my lord, if lordship finally comes to page 122, my lord. Page 181, my lord.
page
181, my lord.
yes.
Thus categorically stated, my lord, the learned counsel appeared on behalf of the respondent McAfee. They categorically stated, my lord, that
The company shall pay gratuity on voluntary retirement for also and voluntary
those persons who sought voluntary retirement.
So according to you,
Lordship.
any gratuity amount
Lordship.
that is going to be offered
Lordship.
or paid is less than the amount prescribed under the Payment of Gratuity Act.
No, I'm not in that dispute, my lord. They have not even granted me payment of gratuity, my lord.
That is right, sir.
Lordship.
So you are entitled to gratuity and the payment of
That is
gratuity.
what my case is, my lord.
That's all.
That's all, my lord.
They have not extended the
They
gold.
have not extended, my lord. That is my case.
Yes, madam.
Your Lordship, I pray for 1 week time, Your Lordship. I kindly pray for 1 week time, Your Lordship.
Week's time.
1 week, yes, Your Lordship.
See, McAfee is an employer under the Payment of Gratuity Act 1972. If more than 10 persons are employed, you have to pay them gratuity. Any scheme which run counter to the Payment of Gratuity Act is very bad in the light of Section 14 of the Payment of Gratuity Act. Do you have the Payment of Gratuity Act with you?
Lordship, I have.
Give it to your friend. See Section 14 of the Payment of Gratuity Act. Page number 20 of the book. Universal Law Lexis. Section 14, madam.
Page 20.
Read it.
Act to override order enactments. The provision of this act or any rule made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act or in any instrument or contract having effect by virtue of any enactment other than this act.
Any act or anything, the word used is instrument. The golden handshake scheme is an instrument which cannot run counter to the Payment of Gratuity Act. And when you have already extended the benefit to another employee in 2021, and that there is no dispute with regard to his employment and the number of days, you have to extend the gratuity for the last 20 or 21 years for services rendered by him. You attain the age of superannuation.
No, Lordship,
You attain the age of superannuation.
Lordship.
Or there is a cessation of relationship between employer and employee.
No, my lord. I've attained the age of superannuation, my lord.
So there are two aspects.
Lordship.
Suppose you have gone out
Lordship.
under VRS
Lordship.
voluntary retirement scheme also,
Lordship.
there is cessation of employer-employer relationship. Still you are entitled to gratuity if you have rendered 5 years of service.
Lordship.
That is why we wanted to ask you whether you have attained the age of superannuation
We have attained it.
or you have gone out based on VRS.
But they told us to go out on VRS, my lord.
Whatever it is.
Lordship.
There is no employer-employer relationship now.
Lordship.
So there, yes. Yes,
Your Lordship, 1 week time, Your Lordship.
1 week.
Yes, Your Lordship.
next Wednesday. Next Wednesday.
Yes, Your Lordship.
Get ready, madam. This is the only point. There are a number of judgments of the Supreme Court saying that contracting out is not permissible. And you will have to pay interest also at 10% per annum. In terms of section 7 capital 7(3) capital A. 10% interest under the Act. If you don't pay it, section 8 will come into operation, which is 15%. Next Wednesday.
Yes, Your Lordship.
Get ready with the matter. Otherwise, we will pause orders. Madam, we have read, I have read the paper. My brother has also read the papers. He has read the papers.
Yes, Your Lordship.
Out of 4, 75% is over. Only 25% is balance. If you don't argue, or we'll say 20%. Balance 20%, you have to write judgment. We'll do it.
Item number 5.
I'll oblige, my lord.
Yes. So please give the list of dates.
Lordship.
When did you join?
Lordship.
And when there is a cessation of employer, and how many years you have worked,
Lordship.
all those things are there. If you see the Payment of Gratuity Act,
Lordship.
there is a format, Form I.
Lordship.
On the basis of Form I only, you will be sending to the employer.
Lordship. I'll
You
do
will be
that.
having that. Fill up that form,
Lordship.
so it will be easy for us to dictate the judgment.
I'll oblige.
Yes. Delay.
The delay has been condoned, my lord.
There has been condoned.
Yes.
Who is on the other side?
Mr. V. Kumar appeared on the last occasion, my lord. I don't see him today.
His name is not been printed. His name is printed or not?
Yes, his name is printed, my lord.
Yes. What is his name? Is Raghu.
V. Kumar appeared on the last occasion.
What displays Raghu? There is no representation for the respondent. In order to give them an opportunity, call the matter on March 13th. I request that you are to come prepared because I am sitting and reading the papers.
Will inform the bar members.
My father has not asked me to read. My mother has not asked me to read. My teachers also not. My PA every day reminds me, bundle has come. You have to read.
It is our responsibility, my lord, for the lawyers to come prepared. My lord.
So every day I'm sitting at 6 o'clock and reading it. Please get ready, the matter. Yes. Yes.
From supplementary list, item number 1.
May it please your Lordship.
Ready?
My lord,
Yes.
papers are needed.
Lordship, the state is before your Lordship challenging the order of learned single judge. Learned single judge by impugned judgment and order, my lord, set aside the order of Deputy Commissioner, whereby Deputy Commissioner directed the removing of toll gates set up by local Sirdarship, CMship. my lord. That order was sought to be challenged by way of writ petition, my lord. Learned single judge quashed the order of the Deputy Commissioner on the ground that the local chieftains have got customary right to collect the toll from mineral-laden vehicles. And therefore, on that ground, the order of Deputy Commissioner is bad. My first contention is, my lord, I will take your lordship to the various pages, my lord. My first ground is, my lord, that the local Sirdar, my lord, they do not have right to collect.
1 minute. Yes, sir.
The local Sardar, or if they call it, my lord, the order is that local Sardar under the CMship, SYEM, CMship, my lord,
SY?
YIEM.
Ah.
They do not have right to collect toll from the trucks or vehicles carrying the minerals.
They have no right to collect the tolls.
Yes,
Yeah.
from mineral. Second contention is, even assuming, my lord, they have some customary rights to collect toll, they cannot collect it. The toll from the trucks or vehicles carrying the mineral. Because trucks or vehicles carrying the minerals, my lord, because it is covered under MMDR Act, Mines and Mineral Development and Regulation Act, and rules made thereunder.
Even if there is a customary right, they cannot collect it.
They cannot collect it. Even assuming they have right to collect tolls, they can collect it from hart or local shops, etc. But they cannot collect the toll from the vehicles which carry the minerals from the designated places, because it is covered by the parliamentary legislation, state legislation.
Can't collect toll
From the trucks or vehicles carrying the minerals.
Yes.
And, my lord, I am covered by the judgments of this Honorable Court and Honorable Supreme Court also. In support of my contention, I will place it, my lord. First, your lordship, kindly see volume 2. I have prepared the compilation, 3 compilation, my lord, and I have shared all the documents, whichever. Compilation number 2, my lord.
Yes.
At page, my lord, 140 is of compilation 2 is the writ petition.
Yes.
At page 168 is the impugn order, which was challenged by the writ petitioner before learned single judgment. 168. June 2016 order, my lord, with reference to the subject cited above, 168, my lord, at volume 2, my lord.
This is the order of the Deputy Commissioner.
This is the order of the Deputy Commissioner.
You given a running number or?
Running number at the top, my lord, at the top.
Continuously for all
Yes,
the-
top, running number.
From 1 to,
1, 2, yes. So your lordship
the
may.
other types it also having a running number or start from first page?
So first page, my lord, each volume has got independent running number.
Oh, India, first from. Because in Chennai we have changed it to Madras.
Yes.
It should be running number.
Running number, this
So
should be
easy
running
for
number.
us to-
Yes, running number.
Volume 2.
168, volume 2, my lord.
Yes.
Now, may I, with reference to the subject cited above, I am enclosing here with a copy of the order pertaining to detailing the magistrate for dismantling the toll gates in East Kasi Hill district. In this connection, I am to request to kindly depute magistrate in place of so-and-so dismantling the toll gate at Ichamati, East Kasi Hill, run by Sri Rest Mawa, authorized by Maulang Sirdar Sikh. Collect 200 per truck of coal, limestone, boulder as it was under jurisdiction. So, the Maulang Sirdar Sikh was collecting, my lord, 200 rupees per truck of coal, limestone and boulder. The direction was issued to dismantle it. This order, my lord, was challenged by in the writ petition, and the averment, my lord, concerning the right of the Sirdar Sikh to collect toll is at page 150 of the writ petition, my lord.
Yeah, page?
150 million of volume, same volume, volume 2. This is part of the writ petition and the averment is there at page 150.
Yes.
It is admitted that Hima Maulang Sirdar Sikh never collect any toll from any mineral or goods carrying vehicle coming from the territories of other neighborhood Sirdar Sikh of CM, but only collect the same from mineral or goods carrying vehicles moving out from the territory of Hima Maulang Sirdar Sikh itself as per customary practice, and the said collection has the origin even prior to independence of India. Moreover, it is undisputed that above impugned letter has been issued by respondent deputy commissioner without issuance of so-called notice either to the writ petitioner or to private lessee. Therefore, above impugned letter has been issued by is highly arbitrary. So the case which has been set up before the learned single judge by the petitioner is that they have got customary right to collect toll from the trucks, and on that basis they have collected they are collecting the toll and they are justified in collecting the toll. My lord, your lordship has seen in page 168, my lord.
Yes.
There is a reference at the page 168 bottom, my lord. There is a reference of the order of the High Court of this Honorable Court, my lord, this order of 18 of 2016. 18 of 2016, dated 3rd May 2016. Page 168, your lordship will see the impugned order, which is under challenge.
Yes.
And at the foot of the page, my lord, a copy of, because this dismantling has been taking place pursuant to the order of this Honorable Court, which is dated 3rd May, that's writ petition number 18 of 2016. So this order, your lordship, will assume some significance for the purposes of this determination, my lord. And this order, my lord, deals with the right of Khasi Hill Autonomous District Council. This order, your lordship will find that order in the volume 1. Volume 1, this judgment and order of this Honorable Court, where the issue was, my lord.
Page?
Page 1, my lord.
2016 decision.
Volume 1, my lord, volume 1, page 1. Your lordship have to... Sadangi or Dakar versus State of Meghalaya, my lord. And then your lordship will, Justice Maheswari judgment. In this case, my lord, the toll was being collected. I was also part of the this matter, my lord. I was also in Supreme Court, and I for respond number 6 only, my lord. But the compulsion is that I also filed SLP and I withdrew SLP.
Is there a problem if I be a part of this bench?
Yes, that issue was there in my mind, my lord. this
My
order,
brother says he was also appearing for the state at the
and I was appearing for private party in this matter in Supreme Court, my lord.
for the district council.
And I also appeared for district council in Supreme Court in this matter, my lord, in 2017. 2017, I also filed SLP and withdrew the SLP. Difficulty is, my lord, that being
Conflict of interest.
difficulty, my lord, as on today is what we are facing problem is that earlier the benches were not there because Justice Dingdo has passed the order. Justice Thank You has recused. So we do not have the bench also, my lord.
And Justice Thank You has also argued the matter.
Justice Thank You has also argued the matter.
So that is the reason why he has,
So, Your Lordship, in Sahara case, the principle of that compulsion is there. Your Lordship has to decide as per law. I am also arguing, though I was for, but I am relying on these judgments. Whatever law is settled in these judgments, I am relying on those judgments. Because in one of the matters, Mr. K.K. Venugopal appeared for the state of Sikkim recently, around 1 month back, in when he was Attorney General. He appeared in that matter, and now he was appearing for Union of India, where the stand of Union of India was contrary to the state of stand. Mr. K.K. Venugopal said that, look, law is now settled. I have to go by law, whatever is settled, so I now can represent Union of India, my lord. So therefore,
that is right.
Therefore, whatever law is there, my lord, we have to go by. If my law is in favor of my friend, because I moved the transfer petition.
See, if you have no objection, I think
I have no objection. My friend will have no objection also.
Madam, I have no objection, madam.
We have no.
The judgment relied by learned AG, where Lordship Justice Padarji appeared, is an altogether different issue. It has no connection with the toll collection. I'll reply. So no objection.
Because this
our
matter has
duty to bring it to your notice.
Yes.
Very important.
Yes, Lordship. That is
Otherwise, only 4 of us were there. And we cannot transfer the case from one High Court to another.
In fact,
you will have to go to the Supreme Court to
No,
transfer the case from one High Court.
in fact, as a matter of fact, we approached the Honorable Supreme Court for transfer of the matter. But after the Honorable Supreme Court, that now quorum is there, so therefore we withdrew the transfer petition. Now, therefore, the matter is being heard, my lord. In fact, in our transfer petition, matter notice was issued because at that point of time there was no quorum, and so.
The quorum is not the way. See, 2 persons have appeared,
Yes, Lordship.
and 1 person has passed an order.
Yes.
And I am the only person who is going to deal with the matter.
Yes, sir. And what my friend says that this fact is distinguishable or not, that your lordship will, and this is the whatever law is settled that we have to apply, my lord. So
That is right. If he has no objection, we have no objection. That's
yes, your lordship. So when my lord, in this case number Sadangi versus El Dakar, my lord, in this case the issue which came up before the KH Khasi Hill Autonomous District Council is a district council constituted under Schedule 6 of the Constitution, my lord, was whether Khasi Hill Autonomous District Council has power to set up the check gates for collection of or verification of the trucks carrying the mineral or not. The learned single judge by detailed order held that you are infringing the right to trade under Article 19(1)(a), and you do not have legislative competence also to frame law relating to collection of tolls. I will take your lordship to the paragraph. And on that ground, the district council was not allowed to have the check gate to carry out the verification exercise. And in the garb of verification exercise, district council was collecting 200 rupees or odd amount from the trucks, my lord. That was set aside by learned single judge. My contention is, my lord, that all sirdarships and all these structures or all these organizations which lordship have, they are all under the district council. They are appointed by district council, they function under the district council, and admitted position is that they work under the district council. I can show one paragraph in the writ petition where averment is there, my lord, that they are appointed by district council, my lord. For that, your lordship may kindly see the writ petition, paragraph 145 of the volume 2, my lord. 145 volume 2, volume 145 of the volume 2, paragraph 2, where averment is with regard to paragraph 1 and 2, I will read both, my lord, at page 144.
140?
144, my lord, of the volume 2. That writ petition number 1 is a rudimentary institution of Hima Maulang Sirdarsip consisting of 7 villages and recognized as the independent Khasi state prior to enforcement of Constitution of India, having administrative, legislative as well as judicial function. The territory of Hima Maulang Sirdarsip now falls within the East Khasi Hill district and also under Khasi Hill Autonomous District Council, created under 6th schedule of the Constitution of India. Paragraph 2, my lord. The writ petition number 2 is the duly elected Sirdar, chief of the said Hima Maulang Sirdarsip under the provisions of United Khasi Hill Autonomous District Council Act 1966. Hence, he is competent to represent the entire people of Hima Maulang before this honorable court for himself or as of them. So, the petitioners are the entities under Khasi Hill Autonomous District Council. This act is of Khasi Hill Autonomous District Council because there are certain legislative powers which have been conferred on Khasi Hill Autonomous District Council under Schedule 6 of the Constitution of India to legislate on certain aspects, including with regard to appointment of Sirdars, my lord.
Yes.
So, when the matter came before learned Singlejan in the judgment, Justice Maheswari judgment, which I was referring to, Justice Maheswari held that the KHDC has no legislative competence, no executive competence to set up the check gate for verification of trucks and collect verification of trucks carrying the minerals. They do not have power to collect verification fees, and the right of the KHDC to collect the fees was quite similar. And kindly see the reasoning given by learned single judge of this honorable court, my lord, and your lordship will see paragraph 5 first at page 2 of the volume 1.
Page 5.
Page volume 1, page 2, my lord. Paragraph 4, my lord, where the similar order is there, paragraph 4, page 2, my lord. The case of the petitioner is that he applied under the notification aforesaid and having found suitable was appointed at KHADC agent for checking of mineral transport challan, royalty challan from all minerals laden vehicle originating from council territory for a period of 3 years from 15th June 2016 as issued by Secretary to the Executive Committee of KHDC, and a public notice was issued by the said Secretary for information of all concerned. The petitioner has also averred that pursuant to the order appointing him, he deposited security amount of so-and-so and challan at so-and-so places, my lord. Paragraph 5. The petitioner has stated that the grievance that despite himself having been appointed and having set up check gate, Deputy Commissioner of West Khasi Hill District, Nongstein, had been interfering with his work and looking to such interference, he sincerely requested Respondent Chief Secretary to intervene and to instruct Deputy Commissioner not to interfere. Petitioner further submitted due to repeated interference representation that Respondent Chief Secretary highlighting inter alia so-and-so. Paragraph 6, my lord. Petitioner has also whether he was not collecting royalty but merely verifying the royalty challans from the coal-laden trucks within the territory of KHDC. When the royalty challan is found correct, he would simply put the counter stamp seal of KHDC showing that coal-laden truck concerned has duly paid the royalty to the respondent. According to petitioner, this verification of royalty challan from coal-laden truck at the designated point is sine qua non for KHDC to prevent the leakage of revenue. Then, my lord, after referring to various provisions, my lord, paragraph 15 at page 4, my lord. Having given, paragraph 15, my lord, at page 4, having given thoughtful consideration to rival submission and having examined the record with reference to the law applicable to this court, is clearly of the view that appointment of petitioner as an agent so as to set up challan, royalty checkpoints and to recover verification fee by the respondent is not supported by law. And to hence the claim made by petitioner cannot be said to be making out a case of infringement of any legal right. Learned counsel of petitioner, KHDC, could not dispute the fundamental position that even when district council is invested with several legislative and executive power, the subject enumerated in para 3 of schedule 6 do not include any item of imposition and collection of royalty on minerals. Even the power of district council to assess and collect land revenue and to impose taxes per paragraph 8 of 6 schedule does not invest it with the power to impose and collect royalties. The matter relating to the royalties under license for dealing with mineral is distinctly provided in paragraph 9 of 6 schedule that reads as under. So paragraph 9, my lord, did not confer any power on the KHDC to collect the royalty, my lord. Then your lordship will see the notification, which is similar notification, which I have pointed out. The next page, page 5, my lord. Office of Executive Committee, Khasi Hill Autonomous District Council, Shillong, middle of the page, my lord. As you are hereby informed that council is pleased to appoint you as the council's agent for checking mineral transport challan, royalty challan from all minerals laden vehicle originating from council's territory, you are allowed to collect a verification fee of 100 rupees only from every single axle mineral laden vehicle and 200 from every double axle mineral laden. This was the notification, my lord, which was challenged, and your lordships as this Honorable Court, my lord, after referring to the various judgments of the Honorable Supreme Court, including judgment of the Honorable Supreme Court in Constitution Bench, my lord, in 23, my lord, written the paragraph 23 at page 8. Even on the principles referred of the referred decision, it is clear that when any executive power is sought to be exercised by the district council like KHDC, it has to act within the parameters of the principles forming the basic structure of the Constitution, including fundamental rights in Part 3 of the Constitution. It is also a matter of little debate that freedom of trade and business remain one of the basic rights of freedom, and any curtailment thereupon has to be backed by law. Yet further, prospecting and mining operations and matters related thereto are to be governed by law applicable to the purposes including Mines and Mineral Development and Regulation Act 1957, and it is difficult to find a direct right with the council to grant any license or lease or to prohibit the movement of excavated minerals. Moreover, it remains trite that any exaction of money in terms of taxes or fees could only be under the specific authority of law. So my submission, my lord, is that the case of the petitioner before learned single judge is that customary right is also law under Article 13, my lord. And therefore there is a backing of law in collection of customary tolls. That is the case which was set up before learned single judge, my lord. The coordinate bench, my lord, held that the Khasi Hill Autonomous District Council has no power under paragraph 3 of 6 schedule to impose or collect toll from mineral laden vehicle. Learned single judge also held that it is covered by Mines and Mineral Development and Regulation Act. The subject is squarely covered. First, there is no power. Second, it is covered by the Act. Third, learned single judge held that this right you cannot take away without having a law. The right. So these three findings weighed with the learned single judge in this case, my lord, in quashing the notification issued by KHDC which authorized the agent to collect the tolls as by way of verification fee. Now, next paragraph. Viewed from any angle, it is apparent that any attempt on the part of KHDC to recover fee from vehicle carrying minerals and to subject them to any checking or verification is neither authorized by law nor is in conformity with the rights of citizens guaranteed by the Constitution. So these two paragraphs, my lord, and then your lordship will find that it was quashed, my lord. This matter was challenged before division bench, my lord. And next page, at page 10, my lord, the order of division bench is there. Division bench, my lord, 16, page 16. at paragraph 28 could not appoint or set up parallel check post over the minerals carrying vehicles and charge verification fee. This was, my lord, taken to the Honorable Supreme Court also. The SLP was dismissed as withdrawn, and thereafter a review also came to be filed against this order. Review was also dismissed, my lord. I'm sorry, there are so many volumes, my lord. In volume 3rd, my lord, last page of volume 3rd, my lord, at page 207, my lord. Petitioners seek review of the judgment dated 207 of volume 3, my lord. Petitioners seek review of the judgment dated 12/10/2017 rendered in writ appeal number title as so and so. Review petition, in fact, on consideration of the record and submission is found aimed at re-hearing the appeal which is beyond the scope of review. Petitioner was appointed an agent of Khasi Electronics District to recover verification from the vehicle carrying vehicle. The officer of the government as alleged by him were interfering with the check points managed by him under so and so. Writ petition was disposed of by detailed judgment on 5/5/2016, just now which I placed, my lord. It was concluded could not appoint an agent to set up a parallel check post or regarding minerals carrying vehicles so and so, and to charge verification for vehicle. Petitioner was held to have no legally enforceable right. Agreed by said judgment, WA was filed unsuccessfully. Appeal was dismissed by this court-wide order dated KSDC had filed was withdrawn. That being so, judgment attained finality. The right of the appellant was limited to an act as agent. When KSD could not appoint any agent in respect of mineral and vehicle, petitioners could not have any enforceable right. So review was also, my lord, after the dismissal of withdrawal of review was also dismissed. The case, my lord, is that the Mines and Mineral Development Regulation Act, this judgment covers my case squarely. My friend relies on one judgment of Guwahati High Court, which I will place, my lord, and say how it is distinguishable, my lord. The Mines and Mineral Development Regulation Act has been enacted for regulating the extraction, mining, transportation, collection of dead rent, royalties. So entire field is occupied by central law and state rules, my lord. Before I take your lordship to the various the rules and regulations, kindly see 6th schedule, my lord, of the Constitution, paragraph 12A. Yes. Paragraph 12A, my lord. Application of Acts of Parliament. Title 12, paragraph 12A, title, my lord. Application of Acts of Parliament of the Legislature of State of Meghalaya to autonomous district and autonomous regions in the State of Meghalaya, notwithstanding anything contained in this. Sorry, my lord. Application Acts of Parliament and of Legislature of the State of Meghalaya to autonomous district and autonomous regions in the State of Meghalaya, notwithstanding anything in this Constitution, if any provision of law made by District Council or Regional Council in the State of Meghalaya with respect to any matter specified in subparagraph 1 of paragraph 3 of schedule, or any provision on any regulation made by District Council or Regional Council in the State under paragraph 8 or 10 is repugnant to any provision of law made by Legislature of State of Meghalaya with respect to that matter, then law or regulation made by District Council or as the case may be regional, whether made before or after law made by Legislature of State, shall to the extent of repugnancy be void and law made by Legislature of State shall prevail. So even assuming, my lord, that there was a customary right vested in the Sirdarship, CMship, my lord, those rights are repugnant to the provisions of MMDR Act,
You are assuming that they have got the right.
even for the sake of argument, my lord, because learned single judge has proceeded on the basis that they are having customary right. My case is that those customary rights have come to an end. after the enactment of the Constitution, after coming of the Constitution, after coming of the various statutory provisions. And I am backed by constitutional scheme, I am backed by statutory provisions.
Yes.
And the judgments rendered by this Honorable Court and even Honorable Supreme Court on this issue, my lord, I will play. So anything which is, even if assuming, my lord, that there is a customary right, but those rights are now extinguished. Those rights do not exist in view of the unequivocal position of the Constitution and statutory rights. My lord, in the light of this submission, my lord, I wish to place
Rights are extinguished.
extinguished, because even assuming, my lord, I am not going into the debate whether they had the customary right or not. Because there is, for establishing customary rights also, my lord, your lordship is aware that they have to lead evidence, to produce material, to show number of things. In writ jurisdiction, those aspects cannot be carried out, my lord. Even assuming customary rights cannot be proved by filing affidavit that I was having customary rights and I placed reliance of one judgment, my lord, because you have to show that this particular Sirdarship was having customary right to collect the tolls, because these customs have to be proved, my lord, because by simple averment in the writ petition, you can't establish that you are having customary rights. But be as it may, my lord, because that debate or that issue may not be required to be gone into, because when paragraph 12A is clear that parliamentary and state law will prevail and any law or any practice which is repugnant will have to give way to the parliamentary and state law. Now kindly see the compilation, your lordship. Kindly come back to the compilation too, my lord, where there are various provisions relating to MMDR Act, my lord, and the provisions that are there, my lord, where the entire field is covered by the parliamentary legislation, my lord. Kindly come to volume compilation 2. And first provision is, my lord, section 15 at page 26 of compilation 2, my lord. Page 26, section 15 of volume 2, compilation.
Page 26.
Yes, page 26, my lord. 26 of volume 2.
Yes.
Power of the state government to make rules in respect of minor minerals. The state government may by notification in the official gazette make rules for regulating the for grant of quarry, leasing, mining leases or other mineral concession in respect of minor minerals for the purposes connected therewith. So under section 15, my lord, the state has been conferred power to make rules, my lord. And under 21, my lord, the power has been vested. 21A, my lord. Punishment is also provided in penalties, my lord. 21A, my lord. And the other section which is important of MMDR, my lord, is
21A,
my lord, penalties. Whether whoever contravenes the provisions of subsection 1 of subsection 1A of section 4 shall be punishable with a term which may extend to. And my lord, 4 is where
penalty provision.
4 provision. 21. Section 1, and your lordship may kindly come to 4, my lord. 4 is the relevant one. Where any person trespasses to any when any person raises, transport or causes to be raised or transported without any lawful authority, any mineral from land, and for that purpose use the tool, equipment, etc., vehicle, other things, such mineral tool, etc., will be seized. So the transportation is covered under section 21, 4 of Mines and Mineral Development and Regulation Act, my lord.
Yes.
Then 23C, my lord. 23C at next page, my lord.
23C.
23, capital C, my lord. 34, page 34, foot of the page, my lord. The power of the state government to make rules for preventing illegal mining, transportation and storage of minerals. The state government may by notification in the official make rules for preventing transportation, storage, mineral for the purpose connected therewith, my lord. And under 23C, my lord, power has been given. A, my lord, kindly see. A, establish a check post for checking of minerals under transit. So 23C confers power on the state government to establish the check post for checking of minerals under transit. So this power has been exclusively conferred on the state government, my lord, under the MMDR Act. Now, my lord, rules have also been framed under section 15. Kindly see page 71, because the rules start, my lord, from page 51, but the relevant rule is, my lord, of Meghalaya Minor Mineral Concession Rule is at page 71, my lord. Rule 26, my lord, of the same volume. Challan for transport of minor mineral. Competent authority shall issue transport challan in Form H to any lease or permit holder who intends to dispatch minor mineral from lease. No person shall transport or carry away any minor minerals from any place without transport challan issued in accordance with sub-rule 1. So under the mandate of law, my lord, the challans can be issued by the state government alone, and state government alone has the right to check the challans and movement of vehicles carrying minerals, my lord.
Yes.
Now, in terms of section 23, capital C, my lord, rules have also been framed, which starts from page 129 of the same volume, my lord, 129 of the same volume, and the relevant rule you also will find at page 131. 131, Rule 4, my lord. Transportation of minerals. Leaseholders or his agent desiring to transport any mineral from his mining lease shall get himself registered in the office of competent authority, registration fee, and then the detailed procedure has been laid down in Rule 4 of the Meghalaya Mineral Prevention of Illegal Transport and Storage Rule 2022. That how the vehicle and material have to be carried out, my lord. Including, your lordship will see at page 133, Rule 5, establishment of check gates. So, this completes my submission on the statutory framework, constitutional framework, right of the state and right of the parliament to lay down and control the entire field of the transportation, collection of tolls, setting up a check gate, my lord. Because your lordship has noticed at page 168 that the collection by the agent of Sirdarship was from the mineral laden vehicles only. Yes. Now, there are two Supreme Court judgment, my lord, on Constitution bench on this issue as to the rights of the Sirdars and whether those rights are extinguished after coming of the Constitution or not, my lord. That judgment your lordship will find at serial number 5 at page 186 of the same volume, my lord.
Same volume.
Same volume. Volume 2, my lord.
Page number?
186. 186. This is the Constitution bench judgment of 1961, SCR, my lord. Then, in this case, my lord, issue was whether without enacting any law, by executing instruction, law can be implemented or not. That was the issue, but in that context, my lord, the judgment examined the rights of the traditional chieftains, and my lord, kindly see paragraph 4 at page 187. Para 4. Before we deal with the main point on the basis of which the writ filed by respondent in the High Court has succeeded, it will be useful to consider what was the position of chiefs in former Khasi states was before 1947 and how that position was affected by coming into force of the Constitution in 1950. Paragraph 4, my lord, page 187. It appears that before 1947, there were 25 such chiefs who had, however, very limited powers. In some of the states, the succession appears to have been hierarchy, but in most of them, chief by whatever name, he was known as elected either by what was equivalent to electoral college or by people generally, the election in many cases being confined to members of certain families known as chief families, but whether the succession was hereditary or the chief was elected by electoral college or by people, the recognition of British government through the crown representative was necessary before chief could exercise any power, and this was covered by means of sanad granted by the chief. It further appears that British government through the crown representative and paramount power reserved itself, my lord, after tracing the history, my lord, paragraph 5, my lord, this further history, my lord, paragraph 5, this position continued till the Constitution came into force. There was no merger as such of 25 Khasi states in India before January 26, 1950. But the Constitution by first schedule, in which the territories of Assam were defined, merged the Khasi state into the state of Assam, and a state was to consist of territories which immediately before the commencement of the Constitution comprised a province of Assam, Khasi state, and Assam tribal areas, but excluding territories spread in Assam boundaries. Thus, by Constitution, the Khasi states were merged in the state of Assam, and any power of chief, so far as administration was concerned, came to an end. By Article 244, Sub-Article 2 of the Constitution, however, special provisions contained in the 6th schedule thereof were to apply to the administration of the tribal areas in the state of Assam. This position, therefore, after coming into the force of the Constitution, was that chief lost whatever ruling or administrative power they had by merger of these 25 states in Assam, and the governance of these states was to be carried out in provisions of 6th schedule. This brings us to the 6th schedule, my lord, and then detailed analysis of 6th schedule is there, my lord. Each and every provision of 6th schedule has been analyzed by the Honorable Supreme Court, my lord.
Yes.
Then paragraph 7, my lord, at page 190. It will be thus seen from the scheme of 6th schedule and district council in both an administrative as well as legislative body. Further, all administrative and legislative power were vested in governor under paragraph 19 till district council were constituted. Governor framed rules, my lord. This was on the issue of rule, under rules, whether without rules framing you can issue the executive instruction or not. Paragraph 8, my lord. We have already observed that administrative power of chiefs as they existed before January 26 came to an end with the coming into the force of the Constitution, and during the transitional period all administrative power vested in the governor could be exercised by those appointed by him under the provisions of para 9 of 6th schedule, my lord. So this issue, my lord, was duly covered, and paragraph page 192, my lord, the Honorable Supreme Court again reiterates what I have read earlier, my lord. So even by Constitution being judgment, my lord, after 26 January 1950, 25 Khasi states did not have any power, administrative or executive powers. Those powers are to be regulated by 6th schedule, my lord. And under the 6th schedule, my lord, I have shown one more judgment, my lord, of the two judges bench of at page 196 of the Honorable Supreme Court as to the power of district council to collect toll from the timbers, etc., my lord. Page 196, my lord. Because under district council sought to collect, my lord, if your lordship will see page 198, middle of the page of 198, my lord, in exercise of power conferred under section 8 of UK Hills Autonomous United Khasi and Jaintia Hills.
Reading, sir?
Page 198, my lord, it is a letter at page 198, middle of the page, where district council has sought to collect the royalty from red pine and white pine, my lord. 20th April 19. In exercise of power conferred under section 8 of United Khasi and Jaintia Hill Autonomous District, as adopted under the Jowai Autonomous District, the Executive Committee of Jowai is pleased to fix a flat rate of royalty for both red pine and white pine under 8 per cubic. This order, my lord, came to be challenged before the Honorable Supreme Court, and it came travel to the Honorable Supreme Court. And then the Honorable Supreme Court, my lord, in paragraph 5, said that district council has no power to collect royalty on toll, my lord, royalty or toll. In paragraph 5, in these appeals, page 199, last paragraph, my lord, in these appeals, we are concerned with the constitutional validity of above said notification. Areas which lie within the jurisdiction of district council, a tribal area which originally formed the part of Assam. Part 10 of the Constitution provides for district administration of scheduled and tribal areas. Clause 2 of Article 244 of the Constitution, as it was originally enacted, reads thus: the provision of 6 schedules shall apply to the administration of tribal areas in the state of Assam. By Assam State Reorganization, Meghalaya Act 1969, Autonomous State of Assam was formed within the state of Assam, consisting of territories which form part of the Autonomous District of United Kasi, Jowai, etc. My lord. Article 244(2) at paragraph 7, my lord. Provisions of 6 schedules shall apply to the administration of tribal areas of state of Assam, Meghalaya and Union Territory of Mizoram. Paragraph 7, my lord. Now paragraph 9. The entire provisions have been read out, my lord. Paragraph, the 6th schedule has been analyzed by the Honorable Supreme Court. Paragraph 9, paragraph 10, my lord. Even each and every power of district council have been analyzed under paragraph 10, my lord. And then conclusion is at page 203, paragraph 11, my lord. It is seen from paragraph 3 and paragraph 8 of 6th schedule to the Constitution set out above, the district council and regional council, in addition to a specified executive council, conferred on them by the other paragraphs in this schedule, have been given legislative powers in respect of certain topics mentioned in paragraph 3 and power to levy taxes specified in paragraph 8. The powers enjoyed by this district council cannot be equated with plenary power enjoyed by legislature. Their power to make laws are limited to the provisions of 6th schedule. The court cannot constructively enlarge their powers to make laws. Paragraph 3 and 8 of schedule of almost same pattern is the subject of list 1 and 2 have been enumerated, while subject relating to taxation are dealt separately in para 8. Paragraph 3 does not contain any subject which authorizes the district council or regional council to levy taxes. Paragraph 3 confers on the said council to make laws only to regulate the matters specified. Paragraph 3(1)(b) empowers the district council to make laws in respect of management of forest, reserve forest. Paragraph 3(2) defines reserve forest. It may also be noted there is no specific reference to levy tax, etc. So the Honorable Supreme Court, my lord, examined the 6th schedule in threadbare manner in both the judgment, Constitution bench, and held that they have no power. And in paragraph 17 of page 207, my lord, the power which district council possesses is mentioned in paragraph 17, my lord, of this judgment, my lord. In the High Court, various.
Where is the order of the learned single judge? How is the learned single judge?
One judgment, my lord, and then I'll take your lordship. One judgment, because learned single judge relies on judgment of division bench of Guwahati High Court, and only one paragraph, my lord, that is there, my lord, and then I'll take your lordship. So that will conclude my argument, my lord. Lordship will see the judgment which is relied by, my lord, at volume 1. Kindly come to volume 1, my lord. Volume 1. Because it is my duty to point out which has been relied by learned single judge against me, my lord. Meghalaya Commercial Truck Owner Association, my lord, and this judgment starts at page 121, my lord. Volume 1, my lord.
1 minute.
Yes, volume 1, my lord. Judgment starts from page 121, but at page 124, my lord, the first paragraph is there. The facts. The census bears on the validity or otherwise of collection of tolls at the check gate set up by respondent district council, the CM of different ilakas located within the West Kasi Hill district, in the state of Meghalaya and their lessees. So this was the issue, my lord. And at the foot of the page, your lordship, at page 125, your lordship will see that the various collections are being made, your lordship would, because if we allow them to collect tolls from each area, my lord, we will have, the state will be replete with check gates all over places. So now your lordship will see page the learned single judge, my lord, the division bench of the Honorable High Court, my lord, at page 147. Uphold their right, my lord, but that right has been upheld in the light of paragraph 147, page paragraph 59, my lord. No post-constitutional law enacted either by the Parliament or the state legislature has been cited repealing, annulling or superseding such customary practice so as to render it non-est thereby. So the division bench, my lord, proceeded on the basis that there is no law which has been brought to the notice because MMDR Act, rules made under the Act, those were not brought to the notice of the division bench, my lord. And that is why the basis or premise on which the division bench has passed the order is that no post-constitutional law enacted either by Parliament as to none is thereby. So the division bench, based on this premise, my lord, held the SLP was filed, my lord, but it was dismissed as withdrawn against this order, my lord. So we have a situation here, my lord, where the division bench has clearly and unequivocally dealt with the check gates, mineral issue, my lord. And then thereafter, my lord, this issue, my lord, right of the district council, my lord, was also subject to recent judgment of the Honorable Supreme Court, my lord, page 18, my lord. Page 18 is that State of Meghalaya versus All the Masa Students Union, 2019, 8 ACC 177, my lord. Page 18. And the power of the district council, my lord, has been dealt at page 75, my lord, which I have, my lord, I have read out, page 77, because the issue arose whether district council has power to control the or regulate minerals or not before the Honorable Supreme Court in 77, paragraph 82, 83, my lord. Now we revert back to Mines and Mineral Development and Regulation Act has been enacted.
77.
I beg your pardon.
Paragraph?
Paragraph 83, my lord, at page 77.
Yes.
The Act came into effect from 1/6, whether there are any indication in the 6th schedule or any other provisions of law by which it can be contended that 1956 Act is not applicable in the hills of the. We first refer to the 6th schedule of the Constitution, which is a provision for admission of tribal areas in state. Paragraph 12A, subclause B empowers the President may, with respect to any act by notification, that it shall not apply to autonomous district, autonomous region, the state of Meghalaya, or shall apply to such district or subject to such exception, modification as may be spared notification. No notification has been issued by President under 12A, B, or 12 in the Constitution with effect from. Thus, there is nothing in 6th schedule of the Constitution which may indicate about inapplicability of the Act with regard to held districts of. So, Honorable Supreme Court authoritatively held, my lord, that the MMDR Act is squarely applicable and examined in detail, my lord. I can take your lordship to the finding also, where your lordship, the Honorable Supreme Court, that MMDR Act is applicable. Now coming back to the impugn order, my lord, in the light of arguments advanced by me, my lord, kindly see, the impugn order is at page 35, my lord.
25.
Or the writ appeal.
55.
No, my lord, now your lordship may leave these volumes, my lord. Only writ appeal, your lordship may take the writ appeal.
Which volume?
Writ appeal, separate volume. I place those judgments also without law, my lord, but I am not taking to. Those judgments are well established proposition of law, my lord.
Yes, sir.
Page 35, my lord. The judgment of learned single judge starts, my lord. My contentions have been noted, my lord, here, my lord, at paragraph 14, my lord, and 15 is on the issue of the learned, on the 15, my lord, on the issue of local session die, rather lack of it, learned AG cited Vinay Kumar versus State of UP and so judgment, saying that they have no legal right, so they cannot come to the writ court, my lord, because without legal right, they cannot come to the writ court. That was my submission. That was now paragraph 16. Coming to the main issue, the learned AG has submitted the petitioner has no jurisdiction to collect tolls from minerals in view of the decision of Honorable Supreme Court, Honorable Court, Sadangi versus so referred to the whereby wide order details similar interpretation and dismiss, holding that there is no legal right therein. Said order passed by learned single of this court in appeal and division bench, so. On the contention of petitioner that collection of tolls within jurisdiction of Siddharthip is in accordance with customary laws and practice has now been required force of law. Learned AG submitted 12A of the 6th schedule of Constitution has clearly provided law made by Parliament will prevail and over the law district council customary laws. The Mines and Mineral Development Regulation Act, my lord, I placed in paragraph 19, 23C, I also placed, my lord. Relevant paragraphs of the judgment I placed, my lord, including all the Masa, your lordship will notice at paragraph 21, my lord. And 22 also, my lord, I distinguished 22, saying that, my lord, paragraph 22 at page 43, my lord. On reliance of learned senior counsel for the petitioner in the case of Meghalaya Commercial Truck Owners, submitted paragraph 19 of the same, it was held that no post-constitutional law enacted either by Parliament or state has been cited repealing, annulling or superseding such as to render it non-est thereby. On the premise that no law has been pointed out, however, here the law has been pointed out in what proposition in has been passed by learned single judge was upheld by division and same being dismissed by as withdrawn and review petition filed also dismissed would also show there is a law with regard to regulating the transport within the state of Meghalaya. Some of they are submitting that petitioner has no legal right. All collection has to be backed by under 19(1)(d) and (g) laid down on consideration of the argument by respective parties before proceeding to discuss the bone of contention between parties. The challenge of the state locus of petitioner is acquired to be taken. It has been contended the petitioner has disclosed legal fundamental rights which infringe has only made a vague reference citing the impugn communication, has described itself, paragraph 25, has rudimentary traditional institution with well-established customary practices, acquiring the force of law to collect tolls and vehicles carrying. And in this respect, we have enacted toll so-and-so. The fact has been acknowledged by in the impugn order, whereby toll gets run by petitioner through agents have been directed to be dismantled. Therefore, assumed right of petitioner to run have been taken away. So, on that basis, my lord, the court said that under 226, 227, they have the right to do it. Now, paragraph 27, my lord. Coming to the main issue, the stand of respondent is that petitioner has no jurisdiction to collect toll from mineral-laden vehicle in light of decision of so-and-so. To the extent it is repetition of brief facts of the case in Khasi, one of the key beneficiaries, my lord, after dealing with my contentions, my lord, paragraph 29. The petitioner, on the other, has maintained that issue is not about the checking up the verify the mineral transport challan or to collect freight from mineral-laden vehicle, and has asserted the right of the petitioner to collect toll, which has been regular practice and has formed part of customary laws governing the administration of Siddharthip, which practice has attained the force of law, as propounded by Lordship in Meghalaya Commercial Truck Owner Association, and therefore interference with the said practice by impugn order, fundamental and legal right of petitioner has been impugned, my lord. And, my lord, I have my lord, I have cited all the Masa, relevant paragraph all the Masa, my lord, all those things. Now, finding of the learned single judge is at page 50, paragraph 33.
Paragraph 33.
33. In the opinion of this court, the argument advanced by learned senior counsel of petitioner has considerable persuasive value inasmuch as differentiation of scenarios so far as collection of tolls and collection of verification fee for mineral is apparent. The collection of verification by the agent was enumerated in Sadangu El Dakar was prohibited on the ground that there is law governing collection of royalty as regard the mineral extracted from the state of Meghalaya, and that is the Mines and Mineral Development Regulation Act, provision 9, paragraph 9 of 6 Schedule of India, which speaks about share of royalty. However, so far as the collection of toll, Honorable Guwahati High Court in Meghalaya commercial case has taken everything into consideration, declared that such collection of toll is part of customary practice which has acquired force of law. It may be reminded that customary practice of collection of tolls from vehicle plying to and from designated territory, Siddharthip, is not for the purpose of collection of royalty or verification of fee of transport, but meant to augment the revenue of Siddharthip. My lord, this, in my humble submission, cannot be ground, or no right can be accrued on the basis that it is going to augment the revenue. If you have a right to collect, you can collect. If you do not have right to collect, augmentation is no ground, which learned single judge. Now, my lord, after holding everything, paragraph 35, there can be no quarrel with the proposition of law laid down by the Honorable Supreme Court in 146 and so on. So the latter of the part so and so. However, the reference of the respondent to state or central law in this context was only confined to Mines and Mineral Development Regulation Act and rules made thereunder applicable to state of Meghalaya. As pointed above, collection of customary is confined not only to minerals but also to goods laden vehicle. But your lordship at page 168 has seen it is the collection only from mineral laden vehicle. Impugn order was not for customary collection of customary duties, it was collection of toll from mineral laden vehicle. So therefore, to
Any vehicle carrying minerals.
any vehicle, rightly put your lordship, that any vehicle carrying. So the whole fulcrum or the basis of the judgment of the learned single judge is that customary right has been upheld by division bench of Guwahati High Court, and based on that, the state has no power. My lord, I have shown the series of judgment till even recent judgment showing that this field is occupied. That aspect has not been dealt by the learned single judge. Learned single judge held that customary right is there. Even assuming for the sake of argument, I argue, my lord, here what is the issue before learned single judge? Issue was whether mineral laden vehicle is subjected to collection of toll or not. That was the only issue. Customary right was not there. Customary right could have been that in respect of other matters, my lord. And that was not the issue before learned single judge. My humble submission, my lord, the learned single judge misapplied the law, and therefore, my lord, I urge your lordship to set aside this order. One more reason, my lord, if we permit in public interest also, that then in that case we have got 7. This is a Sirdarship consisting of 7 villages, my lord. Now there will be mushrooming of check gates all over Meghalaya, and there will be hardly any. The mining activities will come to grinding halt, movement of trucks, movement of trade, and your lordship is aware that under Article 265, no tax can be imposed without the authority of law.
Yes.
That is all I have to submit.
Continue on Tuesday.
My lord, I'll give my reply with lordship permission.
Tuesday.
Tuesday. I have no problem.
In the meantime, we'll also go through the entire paper so it'll be easy for us to follow.
Yes.
Because these issues will keep coming before your lordship.
Huh?
These issues will keep coming before your lordship. Therefore, that's why I placed everything together so that.
Twenty-eight, my lord. Lordship.
Obliged.
Counsel for the appellant concluded his arguments. For continuation for hearing the respondent, close the matter on Wednesday, 28th February.
Obliged.
In the meantime, we have to go to the.
Yes, your lordship will have to absorb the all aspects.
Yes.